done solely by us humans, sex is a very good part of human life.
We live our lives in a great deal of hypocrisy, telling our children to do one thing while we do something else.
The quest for control. We all would love it if our lives were a bit more controllable.
Discussions within the Christian community about these questions will be primary for the survival of the Christian community.
Our second speaker this afternoon is Dr. Thomas Strahan. He is a Minnesota attorney who concentrates his law practice on medical, legal issues, especially related to abortion. He is admitted to the practice of the state of Minnesota as well as before the 8th Circuit Court of Appeals and the U.S. Supreme Court. He graduated from Wayne State University in 1958 with a degree in engineering, and in 1967 he graduated from the William Mitchell College of Law. He is an affiliated attorney with the Rutherford Institute and has authored a law review article published by the Regent University Law Review on negligent physical and emotional injury as related to abortion. He has, since 1987, he has served as editor of the Research Bulletin, which is a publication of the Association of Interdisciplinary Research in Values and Social Change, which concentrates on abortion-related subjects. He has authored numerous articles on the subject of abortion. Would you join me in welcoming Dr. Strahan?
Thank you very much. What I'm going to spend my time doing this afternoon is discussing some of the natural law theories of a legal philosopher and a professor of jurisprudence by the name of Lon Fuller. And I want to highlight some of his key points, particularly as they relate to his references to the Bible, and a few of the implications on how the decision in Roe v. Wade and the subsequent affirmation of Roe v. Wade in Planned Parenthood versus Casey. And the book that I'm going to base my remarks on is entitled A Morality of Law, written by Lon Fuller, and it originally came out in 1964 and it was updated in 1969. It is no longer in print. I did find a copy of it in a used bookstore, and it was originally published by Yale University Press, and it might be possible to get a copy through them. Lon Fuller was, I think, an unusual person. In one way, he's helpful because he said nothing about abortion, as far as I know. And in that sense, I think he represents a potential asset. Another thing, he was very highly respected throughout his many years as a professor at Harvard Law School. And his writings included writings on legal contracts, mediation, comparative law, and legal procedure. He was impressive to me because very early in the 1930s he wrote an article complaining about the form of legal theory in Nazi Germany, which was using a legal positivist view, and very early on Lon Fuller was critical of that. He clashed rather markedly with a number of other legal philosophers, including people such as Hans Kelsen, H.L.A. Hart, Ronald Dworkin, and Marshall Cohen. And to give you an idea, Ronald Dworkin, who was one of his people he clashed with, wrote a book on, it's called Life's Dominion. And in there, Ronald Dworkin says, well, there's an inviolate right to life, but it doesn't apply in cases where there's not much investment in the individual. So even though he says there's an inviolate right to life, he concludes that unborn children or elderly people don't have this inviolate right to life because either we haven't had much investment in them or we've already invested plenty in them and we don't have to invest anymore. So it's kind of a relativistic theory. And so I think it's important for us to take a look at a very well-renowned legal philosopher such as Lon Fuller, who was one of his opponents. The book arose out of a series of lectures which Fuller gave at Yale University originally in 1964, and the book has been republished in a number of languages. In fact, one of the things that Fuller did was to go around to different countries of the world and discuss his understanding of law in helping emerging third world countries to develop a coherent system of law. Now, it's important also to understand that when Lon Fuller talks about law, he doesn't just talk about, think of law as, say, statutory enactments by governmental bodies or court decisions. He would include law, under law, the law that you might have in your family. And I even remember a phrase, particularly as related to fathers, he's going to lay down the law to his children, you know. There was kind of a family natural law, you might say. Also, he would include under law the rules of the Center for Bioethics and Human Dignity. He would include under law the religious beliefs and practices and procedures of various churches. So one of the interesting things about the writing of Lon Fuller is that he has a place for mediating what is called by some writers mediating structures in the society. In contrast to that, I've noticed that in writers like Dworkin and the general legal philosophy of our time is that what we're basically dealing with is the isolated, autonomous individual, virtually nothing in between, and then the state as the other pole. And thus, so everything impinges just on the isolated individual, little or no recognition for mediating institutions, and thus we end up with a doctrine of political correctness, you know, and that's, I think, rooted in the view that that's all we have, really, fundamentally. Now, Fuller was quite critical of what they call the positivist view of law, and he says it's a one-way projection of authority emanating from an authorized source and imposing itself on the citizen. Well, that's what Roe v. Wade did. It does not discern as an essential element of the creation of a legal system any tacit cooperation between the lawgiver and the citizen, morally or immorally, justly or unjustly, as the case may be. The positivists ask of law not what it is or does, but whence it comes. Its basic concern is with the question, who can make the law? In the abortion debate, we have our opponents saying, you know, who decides? The real issue is who decides whether a child can be killed in the womb or not. And so depending upon one's view of law, you can see that you can end up with quite different outcomes. Fuller also observed that a utilitarian philosophy is a major influence on legal positivism. And utilitarianism, he believes, encourages the notion that means are a mere matter of expediency, and that, in fact, means and ends stand in a relationship of pervasive interaction. So Fuller believes that means and ends need to interact with each other, whereas utilitarianism believes that means are a mere matter of expediency. And I think one of the reasons that we have a legalized abortion in this country is because people believe it's expedient and utilitarian. But he says that legal positivism tends to merely be an attempt to serve a managerial function. That's what it would tend to end up if it's had utility as its major goals and does not fully express the meaning and scope of law. And he believes that this method of law, it misses any recognition of the role legal rules play in the making of possible and effective realization of morality in the actual behavior of human beings. He states this: moral principles cannot function in a social vacuum or in a war of all against all. To live the good life requires something more than good intentions, even if they are generally shared. It requires the support of firm baselines for human interaction, something that in modern society at least, only a sound legal system can supply. And so we begin to see that there's a vision that Fuller has about law, that it has a profound and important social dimension. I think that, and that's one of the things that separates him away from the legal positivists. And he attempted to illustrate the idea of a social dimension or social order with the following metaphor, which I found very helpful. He says, imagine that you hold in your hand about 20 pieces of cardboard cut in irregular shapes. Each represents a human being with his own particular capacities, desires, and interests. The pieces are irregular and varied because people are that way. Before you on a table lies a circle within which you must place all of these pieces. This circle represents the total means of satisfying human desires and realizing human capacities. If you allow the pieces of cardboard to drop within the circle in random order, you will find many of them will be stacked on top of each other, leaving blank spaces where there are no pieces, unused space, in other words. By experimenting and patiently rearranging the pieces, you will find that it is possible to reduce radically the instances in which the pieces overlap and push against one another. There is, in other words, a law already given by the dimensions of the circle and by the dimensions and shapes of these pieces, which determines in some measure how they must be arranged to utilize the available space to the fullest advantage and with the least overlapping. Now, one of the things I found about Lon Fuller's book that was very helpful to me in the abortion debate was his discussion of what he called the morality of aspiration in contrast to the morality of duty. These are two important concepts that I found introduced into Fuller's writing. These concepts have apparently not originated with Fuller, but he appears to be the originator of the nomenclature. He says, the morality of aspiration is described as most plainly exemplified in Greek philosophy. It is the morality of the good life, of excellence, of the fullest realization of human powers. In this concept, one might be condemned for failure, not for failure to perform a duty. One might be condemned for a shortcoming, but not for a wrongdoing. Generally, with the Greeks, according to Fuller, instead of ideas of right and wrong, of moral claim and moral duty, there was rather the concept of proper and fitting conduct, which represented a human being functioning at his best. He says, the morality of aspiration stands in intimate kinship with aesthetics and has to do with our efforts to make the best use of our short lives. In contrast, according to Fuller, while the morality of aspiration starts at the top of human achievement, the morality of duty starts at the bottom. It lays down the basic rules without which an ordered society is impossible, or without which an ordered society directed towards certain specific goals must fail of its mark. The morality of duty, he says, finds its closest cousin in the law. The morality of duty is the morality of the Old Testament and the Ten Commandments. It speaks of thou shalt not, and less frequently of thou shalt. It does not condemn men for failing to embrace opportunities for the fullest realization of their powers. Instead, it condemns them for failing to respect the basic requirements of social living. Now, this is an important statement, I think, and perhaps maybe one of the higher statements in his writings. He doesn't discuss it in any great detail, but he does say this. He says, the moral injunction, thou shalt not kill, implies no picture of the perfect life. It rests on the prosaic truth that if men kill one another off, no conceivable morality of aspiration can be realized. He observed that the writings of ethicists discussing the importance of duty are filled with references to the principle of reciprocity. Now, here's another important aspect of it, the principle of reciprocity. In developing the principle of reciprocity, he quotes Jesus' Sermon on the Mount, and where Jesus says, "Judge not, that ye be not judged. For with what judgment ye judge, ye shall be judged, and what measure ye mete, it shall be measured to you again. Therefore all things whatsoever ye that would men should do to you, do ye also even to them. This is the law and the prophets." And Fuller says that the golden rule, this is known as the golden rule, attempts to convey is not that society is composed of a network of explicit bargains, but that it is held together by a pervasive bond of reciprocity. Traces of the concept are to be found in every morality of duty, from those representing heavy appeals to self-interest and those resting on the lofty demands of the categorical imperative. Now, I would like to mention a little bit more about the Ten Commandments, since that was in the title of our talk. And it's interesting, there was a case that was decided back in 1980. It's called Stone v. Graham. It was a case where the Ten Commandments were posted on a schoolhouse wall in Kentucky. And the Kentucky law had required the posting of Ten Commandments on the walls of each public school in the state. But the court, when this was challenged, the U.S. Supreme Court held summarily that there was no, quote, secular purpose to this legislation, and stated, and decided that the state of Kentucky law was unconstitutional. And this is what the court said. This is quite interesting. It says, the commandments do not confine themselves to arguably secular matters, such as honoring one's parents, killing or murder, adultery or stealing, false witness or covetousness. Rather, the commandments concern themselves with the religious duties of believers, worshiping the Lord God alone, avoiding idolatry, not using the Lord's name in vain, and observing the Sabbath. The court thus determined that some portions of the Ten Commandments were arguably secular, others were considered, quote, religious. Now, I'd like to talk a little bit, just briefly, about the portions of the Ten Commandments in which people are admonished to honor God. I think in terms of a democratic society and pluralism that we have, this means basically, I don't think the state can order us to honor God, but I think the state should recognize that we're all moral agents. And what I mean by that is that if we're to be moral agents, there has to be a perfect moral being somewhere on which we draw as a principle. Because if you're a moral agent, that does not mean that the morality is derived from you. It is derived from a perfect moral authority, a higher order, a higher being, a supreme being, the creator, God, if you will. Now, having said that we are all moral agents, does not mean to say that we won't have moral disputes, but they should be based on moral grounds. And this is quite important. Interestingly enough, quite recently, actually back in on March 3rd of 1997, and which wasn't very well reported in the secular press. The House of Representatives in the U.S. Congress made a statement regarding the Ten Commandments in terms of a concurrent resolution. And it had to do with the judge, Roy Moore, a judge on the Circuit Court of the State of Alabama, posting the Ten Commandments in his courtroom. And let me just read to you briefly what the U.S. House of Representatives voted and said. Whereas the Ten Commandments have had a significant impact on the development of the fundamental legal principles of Western civilization, and whereas the Ten Commandments set forth a code of moral conduct, observance of which is universally acknowledged to promote respect for our system of laws and the good of society, now be it therefore resolved that the House of Representatives, the Senate concurring, that it is the sense of Congress that the Ten Commandments are a declaration of fundamental principles that are the cornerstones of a fair and just society, and the public display, including display in government offices and courthouses, of the Ten Commandments should be permitted. So I'm happy to report to you that the Ten Commandments are starting to make some kind of comeback. Now, I think that it's important then to understand that what we need, in my judgment today, and I think what Fuller advocates in his view of law, is that there's of necessity a social order is required of it. There's also minimum standards of duty which must be honored and respected even to have any society capable of functioning. And he discusses some of the problems as to where you draw the line between the morality of aspiration and the morality of duty. In other words, when do you require that a duty be upheld, and when do you require that aspiration? One of the things I've seen in some of these decisions, including Roe v. Wade, and particularly Planned Parenthood versus Casey, but also in some of these assisted suicide cases, is that the court seems to be abandoning the very notion of the idea of duty. You remember, Fuller says it's the law that finds its closest cousin in the morality of duty. And this is one way in which the court can express, its obligation to a social order, saying there's a duty, for example, not to kill one's unborn offspring, or there's a duty to protect elderly people in their last stages of life, or there's a duty and an obligation of a father to pay support for his child. We haven't lost all of these family duties and family notions, but you can begin to see that we've had a rather severe erosion of these. I think also it's a form of, say, imposing a morality, but you impose morality of duty to the degree necessary for the functioning of your society. He says there are three conditions for the optimum efficiency of the notion of duty. The relationship of reciprocity out of which the duty arises must result from a voluntary agreement between the parties. They must themselves create the duty. The reciprocal performances of the parties must in some sense be equal in value. The relationships within the society must be sufficiently fluid so that the same duty one owes today, the other may owe to the first tomorrow. Fuller imagines social bonds that know nothing of duties such as might exist between a couple deeply in love or among a small band of people united by some emergency against an encircling enemy. But he says, as soon as contributions are designed and measured as means, as soon as there are duties, there must be some standard, however rough and approximate it may be. And I suggest the standard is the Ten Commandments, at least. The standard must be derived from the pattern of a social fabric that unites the strands of individual action. A sufficient rupture in this fabric must, if one is to judge the matter with any rationality at all, release men from those duties that had as their only reason for being maintaining a pattern of social interaction that has now been destroyed. And I think that's kind of where we're at. I think we've reached the point that we're in danger of the destruction, internal destruction, not from an external enemy, but because I think the social fabric is started to unravel to such a significant and important degree that I think it threatens not only the stability of the institutions that we have, but increasingly we see their corruption, and their decay and their decline. And he says, if the morality of duty reaches beyond its upward sphere, in other words, too much into the morality of aspiration, the iron hand of imposed obligation may stifle experiment, inspiration, and spontaneity. If the morality of aspiration invades the province of duty, which I think we have in the abortion situation, people may begin to weigh and qualify their obligations by standards of their own, and we may end up with a poet tossing his wife into the river in the belief, perhaps quite justified, that he will be able to write better poetry in her absence. Now that says a lot, see, and I think it applies directly to the abortion question, because that's the reason for legalized abortion. If you read Planned Parenthood versus Casey, the U.S. Supreme Court said, well, we don't believe that a woman is going to be able to take her place in the society unless she has an abortion, and so I think they've overstated the case regarding aspiration and understated the case regarding the morality of duty. He said, the morality of aspiration offers more than good counsel and a challenge of excellence. It can speak and be heard across the boundaries and through the barriers that now separate people from one another. How and when we accomplish communication with one another can expand or contract the boundaries of life itself. One of the things you'll find throughout the writings of Fuller is this constant stressing of communicating with other people. He was a strong promoter of mediation, and he was a strong supporter of social interaction and communication between people. He believes that the morality of aspiration offers a measure of resolution to the problem of who should be included in the community. This is an important question because, in effect, Roe v. Wade and its succeeding cases have really basically stated that the unborn child is not included in the community. Again, Fuller refers to the Bible, where the morality of duty includes the command, "Thou shalt love your neighbor as yourself." A lawyer asked Jesus, "Who is my neighbor?" And Jesus told the story of the parable of the Good Samaritan. The Samaritans were definitely members of the out group. Fuller concludes that we should aspire to enlarge the community at every opportunity and to include it within it ultimately, if we can, all those of goodwill. Thus it is, this is my language, thus it is precisely those who support the right to life of the child in the womb who see that the child is their neighbor. This is in stark contrast to those who are willing to let the child be destroyed. So what we did in Roe v. Wade, in an attempt to be more inclusive of the woman in the community, it was at the expense of another member of the community, namely the unborn child. And this is one of the major differences between the pro-life people and the people who support legalized abortion. We say unequivocally that the unborn child is our neighbor. And Fuller alludes to the story of the Good Samaritan. Fuller further adds that the morality of aspiration is, after all, a morality of human aspiration, and therefore cannot refuse the human quality to human beings without repudiating itself. He quotes a passage in the Talmud that reads, "If I am not for myself, who shall be for me? If I am for myself alone, what am I? If we are for ourselves alone, what are we? Fuller says that whatever answer is given to this last question must be predicated on the assumption that we are above all else human beings. If the answer is qualified by adding some biological tag to our own title, then we deny the human quality to ourselves in an effort to justify denying it to others. Now, if I understand Fuller correctly, I think he'd be uncomfortable with references to different categories of human beings. You know, and I think he's suggesting that if we're all human beings, we call each other human beings or persons or whatever, you know. But we don't need any tags, you know, on it to say, well, we're an African American or we're an Irish American or I'm a woman, I'm a man, I'm a gay person, I'm this, I'm that, I'm an Hispanic American. You know, I think that in a way, although it attempts to be inclusive, there's also something of a separation of it, you know, that we begin to look, I think, at each other, you know, as different. One of the last things I wanted to mention was, I got more in here on this, is Fuller's views on what he calls the internal morality of law. And Fuller says there's 8 ways in which one fails to make a law. It's an interesting chapter in his book. It deals with an allegory of a person who is a king of a newly formed country, and he goes through this allegory. It's quite interesting to read and actually somewhat amusing. But the king makes every mistake in the book, and so he ends up by attempting to say, well, how does one make a law? I won't mention all 8 of them, but I want to mention a couple of them because I think they relate, at least in part, to the abortion question and also law generally. Fuller says, one way to fail to make law, he says, when there is a failure to achieve rules at all, so that every issue must be decided on an ad hoc basis. Now, I'm sad to say that in too many areas of the law today, and that's what the lawyers are waiting for in a given area of the law. They're just waiting for the next decision because the courts are not enunciating principles, you know, of a sufficient breadth and clarity so that one has a reasonable idea of what the law is. Now, in the abortion area, for example, after Planned Parenthood versus Casey, abortion can only be regulated if it is not, in the court's language, an undue burden on the right to abortion. Well, what does the phrase undue burden mean? Well, it means what the judge says it means. You know, we don't really know the degree to which abortion can be regulated. We know that they upheld informed consent laws and they upheld 24-hour notice, and they state, for example, offering literature on fetal development to the woman. But we don't know much beyond that, really. And we have to wait till further decisions of the courts before we can really know that. A third, a related failure to make law, which is related to this undue burden thing, is a failure to make rules understandable. That's another related issue to the undue burden thing because we're not really certain what that means. Another way in which we fail to make law is the abuse of retroactive legislation. I want to give you an example of something that arose in the abortion context. I represented a woman in Minnesota who had been carrying a picket sign throughout the neighborhood of a well-known abortionist in our area. She was arrested several months later after the passage of an anti-stalking law in the state of Minnesota, which basically said that if the victim of stalking perceives some risk or danger to themselves, that violates the stalking law. It not only is a crime, but an injunction can be entered against her. And she was charged with the violation of this law based on conduct that occurred prior to the time that the law had been passed. So we raised a number of legal questions such that the law as applied was void as to her because at the time of her acts, it was not a crime. And also that it violated our constitutional right of being free from what they call ex post facto laws. But the court disagreed with me and upheld her conviction. And I think basically on pragmatic grounds that they just didn't like abortion protesters out in neighborhoods. So there's quite a few different ways in which the law has been altered in favor of what some lawyers call the abortion distortion. You know, there's a sense in which abortion has its own peculiar law and requirements for standing, interpretation of phrases such like undue burden, and many other things have been identified in which subjects related to abortion are discriminated against with respect to the law generally. So I think in some important respects, not only does the existing law fail to meet the standards of Lon Fuller, but increasingly becomes less and less law at all. With that, I think I'll close my remarks and be happy to take any questions. Well, the state of Alabama, there was a judge by the name of Judge Moore there who posted the Ten Commandments on the wall of his courtroom. And I believe he also opened the court with prayer prior to the beginning of the judicial proceedings for the day. And it has become somewhat of a national issue. The Family Research Council, for example, has picked up on it, and there's a bill before U.S. Congress to support the posting of the Ten Commandments. But I think that's just kind of window dressing in a way. I think it's important for us to examine these Ten Commandments closely and carefully, and put some substantive use of them, because I think it's true, as the U.S. House of Representatives said, that the Ten Commandments are important. Let me quote from you from a law review article called "Biblical Parallels in American Law." It was published in the New York State Bar Journal in December 1977, and it was written by a Jewish lawyer by the name of Gary Eddles. And let me just tell you what he said about the Ten Commandments. He says, a democratic legal system must first of all guarantee the life, liberty, and dignity of the human being. The Ten Commandments, apart from establishing a relationship between the people and God, represents a simple yet complete summary of each person's principal legal responsibilities, a classical trichotomy of persons, things, and actions, with an additional section dealing with what might broadly be called procedure. The Sixth Amendment, explicitly prohibiting murder and implicitly prohibiting all crimes against the person, and the Eighth Commandment, prohibiting crimes against property, established the first two fundamental individual protections for persons and things. The Seventh Commandment, prohibiting infidelity and precluding the violation of the most sacred of contracts, has broad implications for protecting the societal fabric, while the Ninth Commandment prohibits false witness, libel, and slander, and implicitly a full range of torturous conduct. Taken together, they govern the regulation of human actions. Finally, the Third Commandment, prohibiting perjury and precluding the invocation of God's name for false statements, establishes the basic procedural rule, namely veracity. So, I think those are the kinds of things that we need to uphold, and whether or not the Ten Commandments are ever formally codified, into statutory law. I mean, that's in effect, the minimum commandments for social living. And I think that whatever we do, that's the least we can do. Any other questions? I either bored you to death or else maybe I just explained everything so well you don't need to. Okay. Well, thank you very much for your time and attention.